Welcome, and thank you for joining us. Please note that this AI-generated podcast is intended solely for general learning and educational purposes. While we strive to ensure accuracy, the AI may occasionally produce errors or incomplete information. We strongly encourage you to consult qualified professionals and conduct your own due diligence before making any legal, financial, or business decisions based on the content presented here. Also, if you find this content valuable, we kindly request you to like the video, subscribe to the channel, and activate the notification bell to receive updates on future episodes. Let's begin.
Welcome back to the Deep Dive. You sent us a really interesting stack of sources about a legal case that just wrapped up, a patent appeal heard by the High Court at Calcutta. We're diving into case number IPDPTA 10-2024, the one between Fiacre Telematics Private Limited and the Controller General of Patents, Designs, and Trademark and another. Think of this deep dive as, well, your shortcut to understanding the key issues, the court's decision, and why it actually matters. And the absolute key takeaway here, straight from the High Court, is a pretty stark reminder for any administrative body making these kinds of technical decisions.
Legit.
You must explain why you decided something.
Exactly.
And you must address the arguments put before you, or, well, your decision simply won't stand.
Yeah, this case is it's a powerful illustration of how fundamental administrative law principles apply, even in really technical fields like patent examination. It shows why procedure matters so much, and it reinforces the standards of fairness, expected from quasi-judicial bodies like the Patent Office. We're going to break down the journey of this appeal, the core arguments, and sort of what the court's decision really means for how these decisions get made.
Okay, so our mission today: extract the crucial insights from your sources, give you a clear picture of this appeal and its implications. Sharp and to the point. Okay, so let's unpack the basics and the timeline first. At its heart, this is an appeal against a decision made by an assistant controller of patents and designs in Kolkata.
Right.
The company, Fiacre Telematics Private Limited, they had their patent application number 11731012587 rejected under Section 15 of the Patents Act. They weren't happy with that, obviously, so they appealed the rejection to the High Court at Calcutta under Section 117A of the Act.
And your sources lay out a pretty clear timeline for how this application moved through the Patent Office, the patent application itself, filed way back in 2017. Then, leading up to April 2024, you had the standard examination process, an examiner's search and report under Section 12. And if objections were raised based on that report, well, the controller would communicate those objections and then call for a hearing. That's under Section 14.
Okay, but here's where things got procedurally complex, according to the sources. Right?
Yeah.
At some point during that process, specifically with the hearing notice, new prior arts, referred to as D4 and D5, were included. And this was significant because these particular prior arts weren't part of that initial examiner's report.
Right, exactly. And sort of compounding that procedural concern, a complaint was lodged against the specific officer who was the assistant controller handling the case. And this was the same officer who would ultimately issue the rejection order. Ah, okay. So that final rejection order, issued under Section 15, it came down on April 17th, 2024. And it rejected claims 1 through 10 of the application, saying they lacked inventive steps as defined by Section 2(1) of the Act.
And the appellant, Fiacre Telematics, they specifically alleged that this rejection order was issued very quickly after the officer found out about the complaint against them. Potentially just one day later, they claimed.
Okay. Following this rejection, Fiacre Telematics filed their appeal with the High Court at Calcutta sometime between April 2024 and May 2025.
And that appeal, IPDPTA 10-2024, it was then heard and decided by the Honorable Justice Ravi Krishan Kapur at the High Court. That was on May 20th, 2025. And that judicial decision, that's the core of the sources you've given us.
So when Fiacre Telematics brought their appeal before Justice Kapur, what were their main arguments? Why did they say the assistant controller's rejection order should be overturned? What went wrong, according to them? Well, their case, based on your sources, really zeroed in on significant procedural and substantive flaws in that April 17th order. Their primary argument was basically a violation of natural justice. They claimed the order lacked any meaningful reasons.
Okay.
And it just didn't show that the officer had actually applied their mind to the case properly. They argued the order merely, restated their own submissions and described the invention, but it failed to genuinely analyze the inventive steps or engage with the specific facts and arguments they'd presented to try and overcome the objections.
And they specifically raised that point about the new prior arts, D4 and D5, showing up late in the process.
Absolutely. That was a key procedural point for them. They contended that including new prior art references like D4 and D5 in the hearing notice, when they weren't in the initial examiner's report under Section 12, well, that just wasn't in line with the statutory process laid out in Sections 12 and 14. They argued it prejudiced them, basically denied them the chance to respond to these new references in writing before the hearing actually happened.
And they felt their detailed arguments, where they explained how their invention was different from the prior art that was considered, were just ignored.
That's exactly right. Their submission was that the order just didn't address or deal with their specific points of differentiation. The reasons they argued their invention did have an inventive step over the existing prior art. They alleged these points weren't even been remotely dealt with in the order.
Strong words. And alongside these points about process and lack of reasoning, there was that serious allegation about the timing, the order coming right after the complaint against the officer.
Yes, the sources show the appellant argued this timing, combined with the, let's say, unreasoned nature of the decision, suggested a potential for bias.
Okay.
That bias might have influenced the conclusion on inventive steps.
Okay, so those were the arguments from Fiacre Telematics. How did the Patent Office, the respondent authorities, counter these points in court? What was their side?
Well, the respondent's counter-argument, judging from your sources, seems to have mostly focused on that procedural point about the new prior arts, D4 and D5. They contended that the appellant's concern about D4 and D5 being in the hearing notice was misplaced.
Misplaced? How so?
Because, they argued, those specific prior arts were not ultimately considered by the assistant controller when the final rejection order was actually passed. So therefore, they asserted, Fiacre Telematics had no valid grievance on that point.
Interesting.
It doesn't really look like, from the sources anyway, that they extensively defended the reasoning or the lack of it in the order itself during the appeal.
Okay, that is interesting. So what's fascinating here is how the High Court, Justice Kapur, evaluated all this. What was the core reasoning that drove his decision in the end?
Well, the court's reasoning focused almost entirely on the fundamental procedural flaws and the critical lack of analysis and reasoning in that assistant controller's order from April 17th. The High Court looked at the order and found that it did indeed just recount the appellant's submissions and describe the invention. It didn't conduct any genuine analysis of their arguments or the inventive steps.
So no real thinking shown in the order.
Pretty much. The court explicitly stated that the conclusion reached about the lack of inventive steps was, and I quote, unreasoned and without any consideration of the relevant materials relied on by the appellant.
So the court agreed then. The order failed that basic test of explaining why the patent was being rejected.
Exactly. The court really hammered this point home. It emphasized that any judicial or quasi-judicial order, like this one from the controller, it has to satisfy what it called the twin tests of why and what.
Why and what? Okay.
Yeah, it cited the precedent from Uniworth Resorts Limited versus Ashok Mittal, highlighting that the why, the reasoning, provides the necessary foundation for the what, which is the conclusion. Reasons, the court stated, are a safeguard against the ipsy-dixit, basically the arbitrary say-so of the decision-making process. The court found the absence of reasons here to be a serious infirmity.
And the court also specifically noted that the appellant's points, distinguishing their invention from prior art, they weren't addressed at all.
Yes, that was identified as a critical failing. Justice Kapur observed that none of the appellant's detailed contentions, including their specific arguments explaining how their invention differed from prior art, their procedural points, the issue with adding new prior art late, none of it was even been remotely dealt with in the disputed order.
Okay. What about the Patent Office's argument during the appeal itself, the one saying, oh, but we didn't actually consider D4 and D5 in the end?
Right. Well, this brought in another really important principle of administrative law, which the court firmly applied. Justice Kapur rejected any attempt by the respondents to bring in new justifications or arguments during the appeal that weren't actually in the original order itself.
Ah, so you can't fix it after the fact.
Exactly. Citing the well-established principle from Mohinder Singh Gill and Ararm versus the Chief Election Commissioner, the court reiterated that an order cannot be improved upon in the written submissions or affidavits, and any attempt to do so is impermissible. Basically, the decision has to stand or fall based only on the reasoning, or lack of it, that was in the order when it was first issued.
Makes sense. Did the court offer any insights into the inventive step analysis itself? Given that was the original reason for rejection, like how prior arts should be combined?
Yes, it did. While the court was mainly focused on the procedural flaws of the order, it did make some important general observations about how inventive step analysis should be approached. It didn't make a final ruling on the patentability of the specific invention, mind you, but it provided guidance. The court reiterated that the claimed invention must be judged as a whole, and importantly, that the mosaicing of multiple prior arts for inventive steps analysis cannot be arbitrarily undertaken.
Mosaicing. So like sticking bits of different prior art together.
Pretty much, yeah. Combining different pieces of prior art. And to explain this concept, the court actually referenced observations from Jacobs LJ in a UK case, Generics UK Ltd v. Daiichi Pharmaceutical Co. Ltd. This reference highlighted that a skilled person in the field wouldn't just randomly pick and choose pieces from different documents unless they were somehow prompted or led to do so,
Right.
either by the prior art itself or just by general common knowledge in the field. This observation sort of suggests the court felt the original analysis might have taken an arbitrary approach to combining prior art.
Which reinforces the need for reasoned explanation again.
Exactly. Why these pieces? Why combine them?
Okay, so based on finding the assistant controller's order fundamentally flawed, no reasons, didn't address arguments, can't fix it later, what was the final outcome? What did Justice Kapur actually decide?
The High Court allowed the appeal. IPDPTA 10/2024.
Allowed the appeal. So does that mean Fiacre Telematics gets their patent granted?
Not automatically, no. The court's order was specifically to set aside the assistant controller's flawed order. And crucially, it remanded the matter.
Remanded it. Okay, what does that mean in this context? Sent back.
Exactly. Remanding means the case is sent back to the Patent Office. The court directed that the application be given a fresh hearing. And importantly, the court specified that this fresh hearing must be conducted by a different hearing officer.
Oh, a different officer. Interesting. The sources didn't spell out the exact reason for that, but given the arguments, especially about bias, why do you think the court mandated a different officer?
Well, you hit on it. Given the appellant's allegations, which included those concerns about potential bias linked to the complaint timing, and the court's own finding that the original order lacked application of mind and was fundamentally unreasoned, directing a different officer just ensures a completely impartial and fresh review. It guarantees that the procedural and substantive issues will be looked at anew, without any, baggage from the previous defective process. It's about ensuring fairness going forward.
Got it. Okay, so the original rejection is wiped out, case goes back for a do-over, someone new hears it. Was there a time frame put on this fresh hearing?
Yes, the court was quite specific. It directed that the new hearing must be completed within 3 months from the date the High Court's order is communicated to the Patent Office. It also stipulated that all parties, including Fiacre Telematics, must be given a full right to be heard during this new process.
And just to be crystal clear, the High Court itself did not make any ruling on whether the invention itself, the one in application 2131012587, is actually patentable or not.
Exactly right. The court explicitly stated it expressed no opinion on the merits of the case. It made it very clear that all questions are left open to be decided in accordance with the law by the new hearing officer during the fresh examination and hearing. The High Court's focus was strictly on the legality and procedural fairness of the previous decision-making process, not on the technical patentability of the invention itself.
Right. So if the court didn't decide if the patent should be granted, what's the real significance? What's the precedential value of this judgment from Justice Kapur? What's the takeaway?
Well, this decision is actually highly significant. It serves as a really strong affirmation and reinforcement of essential principles of administrative law and natural justice. And these principles govern decisions made by any quasi-judicial authority, definitely including the Patent Office. First and foremost, it firmly establishes, yet again, the absolute requirement for reasoned orders. Any decision rejecting a patent application must clearly spell out the why behind the conclusion.
Not just the what.
Not just the what, exactly. An unreasoned order is fundamentally flawed. It's invalid. That's what the Uniworth Resorts precedent highlights. This puts a clear obligation on Patent Office examiners and controllers to properly document their analysis and their reasoning.
And it stops the decision maker from trying to sort of backfill their reasoning later on appeal.
Precisely. It powerfully reaffirms that principle from Mohinder Singh Gill. You cannot introduce new justifications or grounds for a decision during appeal proceedings that weren't in the original order. The order has to stand on its own 2 feet based on what it said when it was issued, period.
Okay. And it also means the hearing officers have to genuinely engage with what the applicant is arguing, right? Not just list the points.
Yes, exactly. The decision underscores that obligation. Simply listing the applicant's points isn't enough. The order has to show how those arguments, especially the ones distinguishing the invention from prior art, were considered and why they were ultimately accepted or rejected. And finally, while it's not, a binding ruling on all inventive step analyses everywhere, the court's guidance on the mosaicing of prior art, referencing the generics UK LTD case, that's an important reminder for examiners. It clarifies that combining different prior art references isn't automatic or arbitrary. There needs to be a logical prompt or reason for a skilled person to actually make that specific combination.
So the big picture impact isn't really about this specific Fiacre Telematics patent. That still needs to be reevaluated. But it's about setting and enforcing the standards for how the Patent Office and other similar bodies have to make and justify their decisions to ensure fairness and transparency.
Exactly. It's a crucial procedural precedent. It's about ensuring that the examination process isn't just technically sound, but also procedurally fair, reasoned, and transparent.
This deep dive into Fiacre Telematics versus Controller General really does demonstrate how absolutely critical those details of process and reasoned explanation are, especially in these highly technical legal areas like patent law.
Yeah, it serves as a powerful reminder, doesn't it? That the legitimacy of a decision doesn't just come from the final outcome, the yes or no, but from the integrity and the clarity of the path taken to get there. Administrative bodies, they have a duty to clearly explain their conclusions and respond meaningfully to the points raised by the people affected by their decisions.
So what does this all mean for you, our listener, based on the sources you shared with us?
Well, it raises a really important question for you to think about. How much weight should you actually give to the reasoning behind a decision compared to just the decision itself? And maybe what are the potential consequences when that crucial reasoning is missing or incomplete? Especially in complex or technical decisions you might encounter, whether that's, a legal judgment, a regulatory ruling, or even a significant technical proposal you have to evaluate in your own field. When the why isn't there, what does that really mean?
Something to definitely think about as you navigate decisions in your own world. That's all for this deep dive. We hope it gave you some valuable insights extracted directly from your sources.